The next matter is State versus Isaiah Curvin, 24 TR 17. There's a name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
That's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem.
All right. This is your first appearance. We were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and request.
Right here is where you start noticing the clash of expectations. The judge is simply outlining the charge. A straightforward Class B misdemeanor, something that's normally resolved quickly with either a fine, a plea deal, or a basic trial date. But Isaiah is already preparing for something entirely different. Many sovereign citizens view even routine traffic charges as constitutional battles, believing that statutory law doesn't apply to them unless they consent. But that's the misunderstanding. Consent isn't needed for traffic enforcement. States have inherent authority to regulate driving on public roads. So while the judge is calmly explaining the rights and penalties, Isaiah is mentally preparing for an ideological battle the court isn't obligated to entertain. Viewers, ask yourselves, have you ever seen a judge so patient when the defendant is gearing up for a debate instead of a plea?
Hearing, so we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license, or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be, it's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, where if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence.
This moment is crucial. Isaiah says he does not understand the nature and cause of action, which is a classic sovereign citizen phrase. The belief is that unless the state proves jurisdiction in a very specific, usually non-existent way, the court has no authority over them. But here's the legal truth. Jurisdiction is already established when the alleged offense occurs within the state. It's not something a defendant can nullify by asking the judge what type of law they're being charged under. Courts operate under statutory law because that's what the legislature created. That's what governs traffic offenses. Isaiah is asking for a legal category, common law, maritime law, that simply doesn't apply. This is where the courtroom tension starts building because the judge knows exactly what Isaiah is doing, and the audience can see the misunderstanding widening with every answer he refuses to give.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Well, Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing.
Here's something every viewer should pay attention to. The judge is giving Isaiah multiple opportunities to simplify his situation. He explains the benefits of an attorney, outlines the consequences of each plea type, and even clarifies sentencing procedures. But Isaiah, representing himself, is walking into the legal equivalent of quicksand. The judge's patience here is remarkable because he's trying to prevent a self-inflicted legal disaster. Representing yourself isn't automatically a problem, but representing yourself while misunderstanding the entire legal framework absolutely is. And you can almost feel the judge bracing for the moment Isaiah starts asking questions the court can't and doesn't need to answer.
A pronounced sentence. If you plead no contest, that is, then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
Well, on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly alleged them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried.
This is textbook sovereign citizen theater. Isaiah mentions a special appearance, notarized documents, constitutional beneficiary status, and claims he sent multiple pages the court didn't receive. This happens frequently in these cases. Individuals submit non-legal documents thinking they override statutory law. But a faxed affidavit isn't a motion. A notarized document isn't a pleading. And referencing Supreme Court cases without context doesn't establish jurisdictional immunity. The judge handles this perfectly. He acknowledges the document, clarifies its limitations, and maintains procedural order. For viewers, this is a great example of why courts rely on formal processes. Not because they're rigid, but because without them, chaos takes over. Imagine if everyone could redefine legal procedure based on personal theories. That's exactly why Isaiah's filings don't carry the weight he thinks they do.
It is difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to
I heard part of what you said, so.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me with regards of the elements of our personal jurisdiction, and also the nature cause of action until the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime amity law. So I can know how to defend myself, and then I can enter my plea.
All right. Have you filed a motion for discovery in this case?
I filed in my I put a special appearance and affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed it.
This is where the judge finally steps in with authority. Since Isaiah refuses to enter a plea, the court enters a not guilty plea on his behalf. Perfectly legal and standard procedure. Isaiah keeps insisting he can't proceed until he understands jurisdiction, but the judge already explained the charge, the statute, and the rights involved. Courts don't need to entertain pseudo-legal conditions before proceeding. And notice how the judge reminds him that even self-represented individuals must follow the same rules attorneys do. This is a powerful teaching moment for anyone watching. Representing yourself doesn't grant flexibility. It requires even more discipline. The legal system functions on procedures, not personal interpretations, and Isaiah is learning that lesson in real time.
It looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a one-page document.
There's only one. It's supposed to be more. I have faxed to more over there. It was supposed to be like 4 pages.
It's one page.
Yeah,
Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
yeah. I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
I cannot answer a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action.
Here we see the final layer of misunderstanding. Isaiah wants a jury trial, which is absolutely his right. But rights still require proper procedure. A written motion is necessary, deadlines must be met, and scheduling must follow the court's calendar. Isaiah asks to reset the hearing so he can resend his documents, but that's not how courts operate. Cases don't pause just because someone's paperwork didn't transmit correctly. The judge lays out every option clearly. File motions, meet deadlines, follow rules. Meanwhile, Isaiah is still thinking he can negotiate the structure of the legal process. It's another example of the gap between theoretical sovereign citizen beliefs and how real courts actually function.
What you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
Because I was my special appearance didn't make it. I need to resend it as well. Uh, can I reset it so I can have a chance to resend my special appearance because it didn't make it in. I guess you already had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before this, 1 hour. Okay.
Miss Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there maybe the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st.
This case is a perfect demonstration of how courtroom procedure, statutory law, and judicial patience intersect. Isaiah's confusion, while genuine, reflects a wider issue with sovereign citizen ideology, the belief that legal theory overrides legal reality. the judge did everything right here. He explained the charge, outlined rights, clarified procedures, and stayed composed even when Isaiah insisted on redefining the process. In the end, the case moves forward exactly as the law requires, not as Isaiah hoped. If you found this case as shocking, frustrating, or fascinating as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Trust me, there are plenty more moments like these coming your way.